Michael Thompson and I are going to be speaking about attorneys' fees, awards, and patent litigation in the U.S., UK, Canada, and to a lesser extent Germany. I thought it was a topical subject given some cases in the U.S. And given that UK and Canada both have loser pays assumptions to start off with. So that's where we are today. I'll let the other speakers introduce themselves now.
Sure. My name is Michael Thompson. I'm with McAndrews, Held & Malloy in Chicago, Illinois. We're an IT boutique, and I've been practicing in the patent space since passing the bar.
And I'm Michael Carter from Gowling WLG in the UK. Work between the London and Birmingham offices here, and have been part of our IP team for about 5 years, and tend to focus on automotive and tech patents.
Wonderful. So this is Michael Thompson again. To start, we thought it would be helpful to provide a quick overview of U.S. patent law and the state of attorney's fees in the United States. So generally, lawsuits that can be filed in the U.S. federal court can also be filed in state court. There are exceptions. These exceptions are where the federal court has exclusive subject matter jurisdiction, and patent infringement is one of those exceptions. So typically, patent infringement actions are brought in U.S. district courts. There are, however, other venues, including the U.S. International Trade Commission, and they're better known as the ITC. So while each of these venues is equipped to evaluate patent infringement cases, the U.S. District Court is by far way more popular, as it can also award monetary damages, while the ITC is limited to exclusion orders, effectively blocking importation of infringing products. So in the United States, contrary to Canada and other jurisdictions, as a general rule, each party pays its own attorney's fees. However, the prevailing party can seek an award of attorney's fees by filing a motion under Section 285. And what does Section 285 require? Well, looking at the statutory language, it simply says that the court in exceptional cases may award reasonable attorney's fees to the prevailing party. Well, that begs the question, what does exceptional mean? And that, however, depends on the time frame. Prior to 2005, the Federal Circuit instructed district courts to consider the totality of the circumstances when making fee determinations. And that determination was reviewed only for clear error, and the decision to award fees and the amount of the fees was reviewed for an abuse of discretion. In 2005, the Federal Circuit abandoned that equitable approach in favor of a more rigid and mechanical formula. This formula is better known as the Brooks Furniture Test. Now, the Brooks Furniture Test, in that case, the Federal Circuit found that absent material inappropriate conduct, like a Rule 11 violation, a party must prove by clear and convincing evidence both subjective bad faith and objective baselessness in order to show that a given case is exceptional and thus entitled to a fee award. As a result, because of Brooks Furniture, attorney's fees awards became relatively rare because it was practically too hard to prove. But this all changed more recently in 2014 when the Supreme Court decided the Octane Fitness case. And to provide a little background on the Octane case, so in 2008, Icon, a large manufacturer of exercise equipment, sued a much smaller competitor known as Octane Fitness for patent infringement in the District Court of Minnesota. And the subject matter related to elliptical machines. The District Court granted summary judgment of non-infringement in favor of Octane Fitness. Octane Fitness then requested attorney's fees under Section 285, arguing that Icon brought the lawsuit in bad faith as a matter of a commercial strategy. And they had various evidence, including emails saying that they were looking to crush them just to get them out of the market. So Octane noted that not only was Octane not practicing the patent, but upon a mere visual inspection of the accused product, it was clear that there was no infringement. So ultimately, the district court relied upon the Brooks Furniture Test and denied Octane's motion for fees. In doing so, the district court found that there was no subjective bad faith. On appeal to the Federal Circuit, Octane argued that the district court applied an overly restrictive standard in refusing to find the case exceptional under Section 285. Basically, Octane wanted to lower the standard because for an exceptional case to objectively unreasonable because it's so hard to prove subjective bad faith by clear and convincing evidence. That is, the plaintiff's claims were meritless and that the plaintiff knew that they were meritless. the Federal Circuit ultimately affirmed the district court in a very short opinion, stating that they had no reason to revisit the settled standard of exceptionality. So Octane filed a petition for cert to the Supreme Court, and the question presented was whether the Brooks Furniture framework is consistent with the statutory text. 15 amicus briefs were filed. Each argued for a change in the Federal Circuit Brooks Furniture standard. In fact, nobody filed a brief in support of ICON's current standard. On April 29, 2014, the Supreme Court reversed the Federal Circuit in Octane Fitness. The Supreme Court found that the Brooks Furniture test is too restrictive, noting that, according to the statute, a case just needs to be exceptional, not virtually impossible to prove. The Supreme Court therefore clarified that an exceptional case is basically one that stands out from the others with respect to the substantive strength of the party's position or the unreasonable manner in which the case was limited. It, in other words, eliminates the requirement for both subjective bad faith and objective baselessness. Either or became enough. And the court correctly noted that nothing in Section 285 justifies the clear and convincing evidence standard, that exceptionality can be proven by a preponderance of the evidence. Later that same year, the Supreme Court also decided the Highmark versus Allcare case, and Highmark addresses the standard applied when reviewing Section 285 determinations on appeal. Now, in the district court in that case, the Highmark, who's a healthcare provider, brought a declaratory judgment action in district court against patent owner Allcare, seeking a DJ of non-infringement of a patent directed to a method of managing healthcare systems. Allcare counterclaimed for infringement. The district court granted summary judgment of non-infringement. Therefore, Highmark moved for attorney's fees. The district court found that the case was exceptional and granted fees. The court found litigation misconduct, namely asserting a frivolous position, shifting claim construction, and misrepresentations related to motions to change venue. Allcare then appealed the findings of the Federal Circuit. The central issue was whether Allcare's claim constructions were frivolous. The Federal Circuit ultimately affirmed as to one of the infringement claims, but reversed on the other, finding that Allcare's claim construction was in fact reasonable, so no fees as to at least one claim. In review, the Federal Circuit reviewed the objective baselessness inquiry de novo. On dissent, interestingly, the Judge Mayer criticized the Federal Circuit as being increasingly infatuated with a de novo review, such that the district court proceedings are merely a dress rehearsal for the command performance to the Federal Circuit. I thought that was interesting. So Highmark ultimately filed a petition for cert to the Supreme Court, and there the question presented was whether a district court's exceptional case finding under Section 285 is entitled to deference. The Supreme Court ultimately vacated unanimously the Federal Circuit decision, holding that all aspects of a district court Section 285 determination should be reviewed for abuse of discretion. And the Supreme Court reasoned, in part, that the district court is better positioned to decide exceptionality because it has lived with the case for a prolonged period. So, with that, in view of Octane and Highmark, there's been an increase in motions for fees. There's also been an increase in granting these motions for fees. So what does that mean for you? First and foremost, plaintiffs should be sure to perform an adequate pre-filing investigation, and during litigation, one should track misconduct. Now, the process for seeking attorney's fees under Section 285 is relatively straightforward. Once the judgment is rendered, the prevailing party moves for a determination that the case was exceptional under 285 and can then seek an award of attorney's fees. Each party will brief the issues, and typically there's a hearing addressing the fees. Now, even if an exceptional case is found, the court still has discretion to determine the appropriate award. Sometimes that award can even be zero. Generally, courts determine the number of hours by relying on evidence of time records, expense statements, and detailed itemized billing records. Another approach is the Lodestar Calculation, where the court determines the fee based on a reasonable number of hours multiplied by a reasonable hourly rate. And that might come up in, for instance, if you're doing a pro bono case, something to that effect. In assessing the reasonable royalty, courts often look to surveys such as those from AIPLA and others. publications. Even if an award is granted, the court must determine whether the fees requested are, in fact, reasonable under circumstances. And the court can consider a number of factors. Some of these include the novelty and difficulty of the questions, the skills required to perform the legal services, customary fees for like work, which goes to the AIPLA type surveys, the amounting controversy, fees awarded in similar cases, and the like. So with Highmark, and it's become much easier to get fees, so there's an increase in such fee motions. And with that, I will turn to Will Boyer, who will discuss it from a Canadian perspective.
Thanks, Michael. I have one question, actually. The factors that you have there, are those entrenched in a regulation or rule, or are those just from case law?
It's from case law, and there are about 12 of them, and they're on my slides, but the court does have discretion to look to others. Those are the most common 12, and a number of the circuits in the United States do consider those 12. I think it dates back to like 1976, Johnson versus GA Highway Express.
Okay, interesting. And I just raised that because, as we'll see when we get to the end of my discussion, the factors assessed by Canadian courts are actually ingrained in the rules. And they're right there for the court to look at and see which factor applies and which one doesn't. So it's a different approach. So coming now to the Canadian perspective, I'll start with venue. The venue doesn't matter too much in the sense of attorney's fees, because in each provincial jurisdiction and in the federal jurisdiction, it's very similar. You're awarded your attorney's fees based on the tariff, and the tariff is basically this chart set out in the rules that say for this, and I have the sample in the slides, but the tariff says for this item, for preparing your pleading, you get 4 units, and that's multiplied by the unit value, and there's your fees. So they don't, when awarding attorney's fees, it's pretty rare that you get to look at the other side's dockets and look at their hourly rates and see what they actually billed. It's more based on this tariff system. So that's both in provincial and federal courts. With that said, most patent cases are brought in the federal court. I'd say about 95%, if not 99%. The reason for this is pretty simple. With a federal court case, you can get an injunction throughout Canada. So instead of just bringing your patent infringement case in the Ontario court and getting an injunction in Ontario, then having the infringer go to British Columbia and infringe in British Columbia, if you go to the federal court, you can get that injunction throughout Canada. From the potential infringers or from the defendant side, federal court's better because only the federal court can issue these declaratory judgments. So the declaration of non-infringement or declaration of invalidity, you can only get that from the federal court. Provincial courts do not have jurisdiction to do that. So for those reasons, we're typically in the federal court when we deal with patent cases. So the cost analysis, the way it works is whenever you go to court, even on an interlocutory injunction or any sort of injunction or any sort of interlocutory motion, you're going to have a winner and a loser. And the judgment almost always reads motion allowed or action allowed, cost to the plaintiff, cost to the applicant. So costs are presumed that you're going to, if you win, you get your cost. That's a rebuttable presumption in certain rare cases that can be rebutted. So, for example, if you ultimately win, but your case was littered with litigation misconduct by the party, the successful party, the court might say in the circumstances you don't get your costs in this case. And again, like I said, it's not full reimbursement of your costs. You don't look at the dockets and see what you spent. You go to the tariff and you see for this unit, for this step in the litigation, you get these amount of units times the unit value, and that's your cost. So look at the tariff now. It's in the rules. If you have the slides, I have them in the slides there. I only provided the first 3 items in the tariff in the slides, but there's about 28 items, and it goes through every step of the litigation. So it's preparing a statement of claim, preparing a defense, examination for discovery or depositions, trial, pretrial steps. All the steps are there, and you're awarded a certain number of units. So the court will say costs awarded to the plaintiff at mid-column 4 throughout the entire case. So then you go to the tariff and you see mid-column 4, that's between 5 and 9 items for 5 and 9 units for preparing and filing and originating documents, such as a statement of claim. So then you would get 7 units, say. You look to the unit value. Unit value right now is $144, so that's set in by the federal court. You multiply 7 times 144. That's what you get for preparing your pleading. So you get about $1,000 bucks. And I'm sure we can all appreciate that you spend a lot more than $1,000 when preparing your pleading. So it's pretty minimal what you get in comparison to what the actual amount spent. That's recognized right now amongst the IP litigation bar, and likely amongst other bars as well. I think these rules were drafted in 1989, I think, and the unit value has gone up, but the number of units has not, and it's pretty outdated. So there is a movement to try to get that updated and have costs reflect more what people are spending. There was a recent case. What a court can do in some cases is completely depart from the tariff. If they see the tariff is going to award you $500,000 for a case you spent $10 million on, the court is pretty lenient to do that. They kind of want you to get something more than that back. So that happened recently, started this year in a Dow Chemical v. Nova case. A case dealt with polyethylene compositions for plastic bags and stuff like that. It was a hard-fought case. There was lots of experimental testing, lots of counsel involved. The plaintiff ended up spending about $10 million in legal fees, and the court noted when they went to assess costs, the court noted that high column 4, which is typically or high column 5, which is higher than what you typically get in a patent case. You normally get around mid column 4. High column 5 would have been about $1.1 million, and it would have been about 10% of what they spent. So the court didn't want to go there. They wanted to make the cost reflect what was actually spent. So that's when they actually looked at the dockets and see what was spent and how much should we award here, what's reasonable in the circumstances. And they ended up awarding $2.9 million, so still a fraction of what was actually spent, but we're getting closer, and $3.6 million in disbursement. So typically you get your reasonable disbursement. I was mainly talking about attorney's fees before, but most disbursements you will get back unless there's something that's completely unreasonable there. It's the attorney's fees that are typically lower. So this Dow case was pretty, lots of people were talking about it at the start of the year. It was the highest award of attorney's fees and disbursements in ever by a wide margin, by multiples of what was previously awarded. When we advise clients, we typically say for a hard-fought case, the court might award $1 million against you if you lose. This case went 4 or 5 times over that, so it was pretty groundbreaking, and it's interesting to see what's going to happen coming next for any other cases that are finishing trial and now we're going to cost. It'll be interesting to see how the court goes and whether they do take a similar approach to depart from the tariff and just order something based on the dockets that are spent. So like I mentioned at the start, when the court goes to assess costs, they go to the Rule 400 factors. So that's in the federal court rules. There's I put some of them in the slides. There's a lot more than that, though. There's 10 or 15 factors that the court can look to. Pretty similar to what Michael Thompson was mentioning. You look to the results of the proceeding, inducement, including apportionment of liability. So if you win on, in a patent case, if you win on 4 of the 5 validity attacks, but one of the validity attacks won and you end up losing, the court might award reduced fees because you won on those 4 or 5 issues but lost on the one and therefore lost the case. So the court will take that into consideration. The amounts claimed and amounts recovered. Again, if you're claiming $100 million and you get $1 million, it's sure you won the case, but if you were pushing hard for that $100 million, you might have incurred costs on the other side for that, and the court is going to take that into consideration. Importance and complexity of the issues. That's less about the technology, less about if the patent is for cutting-edge technology, and it's more about the legal issues. Are these complex legal issues that require the parties to spend a lot of money to research, develop arguments around, and then present to the court in a cogent manner? So again, in patent cases, you typically see parties go to the court and say, This was for a novel compound, chemical compound, and it's very cutting-edge technology, and therefore it's a complex case. Courts don't really buy into that, and they look to the legal issues and not the scientific issues. Amount of work, so this gets into, like we saw in the Dow Chemical case, where the parties spent a lot of time doing a lot of different things, like experimental testing, several counsel involved. The court, in that case, looked at the amount of work and said, we got to award something more than just the tariff-based fees. Whether the public interest in having the case proceeding. So again, does the public benefit from this? Is there something that this plaintiff, although they lost, it was good for them to bring this case for public policy reasons, and therefore they might award reduced costs against that plaintiff. You don't see that much in patent cases, because patent cases are less about public policy and more about people infringing patents or people alleging infringement. So you don't really see this factor applied in these circumstances, but it is there. And there's several other factors. I don't want to go through them all. I just want to hit some high-level ones there. So the process for getting your fees once the case is over, so you get a judgment, plaintiff in a patent infringement action, action allowed, defendants found to infringe. The court order is going to say action allowed, damages are blah, you get your injunction, and costs go to the plaintiff. Typically it's as bare as that, and the parties are then asked by the trial judge to submit submissions on costs. Within 10 days, that's a typical time frame, within 10 days of the end of trial, 5-page submissions on costs on what you think the cost award should be. So parties go back after trial and they write to the court with these submissions. It's typically in writing, there's no oral hearing. And they'll argue either for, a plaintiff in that case will argue either for a lump sum and say tariff shouldn't apply because we spent way more than what the tariff is, and it's just not just in the circumstances to award tariff-based fees. So we have to depart from the tariff. And here is our dockets, and here's what we spent, and here's what we think the award should be. The alternative approach is to say there's flexibility within the tariff. You get, for example, examinations for discovery. You get a certain amount of units per hour at the examination. That's typically one counsel. But most examinations, there's 2, maybe 3 counsel there. So what parties have started to do is when they put their cost submissions in and say, we want tariff-based fees for 3 counsel at the examination for discovery. So multiply whatever the tariff is by 3 units, and then multiply that by the unit value, and that's what we should get. Same with trial. The tariff allows for 1 attorney at trial. That's obviously not the way it happens in large patent litigation matters. So parties will write and say we should have 3 of the whatever the unit value is, mid-column 4, 3 of those for each lawyer that was there, and get those fees. So then you start to see the fee awards go up. So parties submit these submissions. Court's going to make a decision on either awarding a lump sum or they're going to say no. So here's how they're going to give directions as to cost. So for this tariff item, you apply mid-column 4 and 3 attorneys. For this tariff item, you apply mid-column 4 and 2 attorneys. And then the parties are sent off to try to resolve costs on their own. So then there's negotiations amongst the parties, and if they don't come to a resolution, then they write to the court and ask for a reference as to costs. So the federal court at least, has assessment officers that essentially their job is to assess costs. They have other roles as well, but one major role is to assess costs. So the parties will write, it's basically like a mini motion. They write to the court, to the assessment officer, and say, here's what we think costs should be based on the court's direction and based on the tariff. Competing submissions are sent, and then there's an oral hearing before the assessment officer, and that assessment officer will make a decision as to cost and come to a final value and say that the plaintiff, in this case, you get X amount of dollars. And that sort of resolves it. You can appeal those decisions, but you don't see many cost decisions appealed. By the time you get there, it's diminishing returns, and you're talking about, is it going to be $1.4 million or $1.5 million? It's no real value to go to an appeal there. So that's it for the Canadian perspective, and I'll pass it over to Michael Carter now for the UK perspective.
Thanks. Well, so yeah, I am going to cover. We've termed it the UK perspective, but in reality, it is the England and Wales perspective. The UK legal systems are split up, so Scotland has a separate and distinct legal system to the rest of the UK, and the Court of Session in Edinburgh is able to hear patent cases, and that is under a completely separate system to the rest of the UK. So other than mentioning that it is there and it is in existence, and it is a specialist IP court, I don't intend to cover the Scottish system today. Instead, what I'm planning to focus on are the two venues we have for patent litigation in England and Wales, which are the Patents Court, which is a division of the Chancery Division, which has specialist IP judges, most of whom in the patent sphere have a background, some technical background of one way or another. It's also got specialist rules for dealing with various patent issues which arise, experiments and the like, and is getting quicker. So if we'd spoken probably 2 years ago, I would have told you that a High Court action in the Patents Court would take probably 15 to 18 months. The average is now probably 9 to 15 months, although a decision was handed down in the last few weeks, which saw the length of time from issuing proceedings to a Court of Appeal judgment being less than 6 months, and that took 4 months to first instance. So things can happen very quickly if the parties and the court agree that that is to take place. The Patents Court still attracts the majority of patents cases, as you'd expect, but over the past 5 years or so, there has been a court called the Intellectual Property Enterprise Court, which is designed for smaller patent disputes that can be heard within 2 days. That has a cap on the recoverable damages of £500,000, but there is no restriction on the ability to grant injunctions. So for most patentees, particularly if they are smaller companies, it is quite an attractive system. And the reason why it is worth mentioning in a presentation on costs is that it has a very different approach to costs to the rest of the UK legal systems, in that the recoverable costs of the successful party are significantly capped at £50,000. So moving on to the recovery of costs more generally, the rules for that are set out in the UK Civil Procedure Rules, and that's at Part 44 of the rules, and that will apply to all claims in the High Court, including in the Patents Court. And whilst the rules go into quite a lot of detail as to what the default position on costs should be in English proceedings, it starts by emphasising that costs is a matter for the judge's discretion, and the judge has quite a broad discretion as to costs awards. So it's made clear that the judge has discretion as to whether costs are payable at all, what the amount of those costs are, and when the costs are to be paid, although usually that is within 14 days of the order. Bearing that in mind, and bearing the judge's discretion in mind, the general rule set out in the civil procedure rules is that the unsuccessful party will be ordered to pay the costs of the successful party. That is a fairly long-held position in English law, but is also supported by the European law, which is relevant to IP claims. So because intellectual property is harmonised to an extent across the European Union, European Union law, at least for the moment, plays quite a big role in certain IP cases. And the EU is also a loser pays system, and the enforcement directive of the European Union states that reasonable and proportionate legal costs and other expenses incurred by the successful party shall, as a general rule, be borne by the unsuccessful party unless equity does not allow. Now, we'll come on later to briefly consider the position in Germany and the Intellectual Property Enterprise Court. And I mentioned earlier that the Intellectual Property Enterprise Court is a costs-capped system, and the same is true in Germany. The fact that the enforcement directive states that costs should be recovered does not mean that costs capping is not permitted, but a recent case has thrown some doubt onto the extent to which cost capping is permitted. And this was a case that was handed down in July this year called UVP and Telenet, where the Court of Justice held that any cap must reflect the reality of the rates charged for the services of a lawyer in the field of intellectual property, and on the other hand, at least a very significant and appropriate part of the reasonable costs actually incurred by the successful party are borne by the unsuccessful party. So there are effectively two limbs to get over if you are in a costs-capped regime, whether that is in Germany or in the Intellectual Property Enterprise Court. And that is, first of all, the rates which the cap allows must reflect the reality of the services of a lawyer in the field of intellectual property. Now, that effectively means that it has to be at least proportionate to what you'd expect to pay a lawyer for dealing with a patent claim, and at the same time, a significant and appropriate part of the reasonable costs need to be borne by the unsuccessful party. So that is fairly strong guidance that, according to European law, this is a loser-pays system, and even in cost-capped regimes, there may be some support for trying to depart from the rules of those regimes, and we will see how this plays out over the next couple of years. The upshot in the Telenet litigation, which was litigation in Belgium, was that the lawyers' fees sought by Telenet were 185,000 euros, and they also sought 44,000 euros in disbursements. The costs cap that applied in Belgium was 11,000 euros, which limited the amount that Telenet was able to recover to that amount. One suspects that in light of the Court of Justice decision earlier this year, there is a good argument for Telenet recovering a greater proportion of their costs. So moving into UK costs and the costs of the High Court and the Patent Court, there is the rule that I explained earlier that the loser pays is the general approach to all types of civil litigation within the High Court. In patent cases especially, there is the added complication that it can sometimes be quite difficult to identify who the successful party is. And I know Will was talking earlier about the Canadian federal courts stating in their judgments effectively who the winner and who the loser was. That's something which unfortunately the UK courts and the High Court in particular doesn't ordinarily do. They will normally conclude judgments by saying effectively that the patent is valid or invalid and infringed or not infringed. In most cases, that will be perfectly sufficient to work out who is the winner and who is the loser. But in cases where you maybe have multiple patents in suit, it can be slightly more problematic. or where a party wins on many issues but maybe loses overall. And in those cases, the courts adopt what is known as an issues-based approach to costs assessment, and that was set out by Lord Justice Pumphrey in the Monsanto and Cargill litigation back in 2007, and has been approved by the Court of Appeal in subsequent case law. And that case, the Monsanto case, sets out the basic proposition for patent cases as follows. The overall winner is likely, save in the most exceptional circumstances, to be entitled to payment of all his costs which are not or cannot be allocated to a particular issue, or which are general costs of the action. However, it then goes on to say, if costs are suitably circumscribable so that they can be properly allocated to issues upon which the overall winner has nevertheless lost, there are two questions. Firstly, whether that party should recover his costs of that issue, and secondly, whether the case is so exceptional that the winning party should pay the unsuccessful party's costs incurred in respect of that issue. So there is whilst it is still very much a loser pays system, it is an issues-based loser pays system, and in certain circumstances, the overall winner can pay something towards the overall loser's costs of a certain issue. And this has been considered more recently, and the justification behind it has been considered. And the idea is that parties should be encouraged to pursue their best points only, and that's why the court adopts this issues-based approach. This was considered, as you'll see on the slides, in Hospira and Cubist, and in that case, Hospira pursued an argument that the skilled person would not know and would not be able to make a particular compound. This was notwithstanding the fact that Hospira knew that for at least 20 years, skilled teams in industry had in fact been able to make that particular compound. And they had also lost on this point, although winning the case overall, in parallel US proceedings. And this was one of those issues which was considered to be suitably circumscribable, and also was an issue which was so exceptional that the winning party should pay the losing party's costs of that issue. And as a result, the court reduced Hospira's recoverable costs by 20%, which reflected the costs that Hospira could not recover and the costs that it would have had to pay to Cubist, which were offset. The way in which the amount of offset is calculated is a fairly crude approach. Simply, the parties tend to try and justify that by counting the paragraphs relating to a particular issue in the pleadings, the skeleton arguments which are filed at court, and in the judgment itself, and allocate a proportion of their overall costs to that issue. Turning to what is actually recoverable itself in terms of the costs, sort of cold hard cash that's recoverable, the costs can only be recoverable if they're reasonably incurred and reasonable in amount. So in Will's presentation, there was a lot of discussion about what was reasonable. We have a similar approach here in the UK, and it is getting more strict as to what the courts consider to be reasonably incurred costs and reasonable in amount. Historically, the rule of thumb has been that you would recover maybe 60 to 70% of your actual costs, as a successful party, although things are changing, and it has always depended on what basis the costs are awarded. So in the High Court, costs are ordinarily awarded on the standard basis. However, there is another basis that they can be awarded, which is the Indemnity Basis, which effectively punishes a unsuccessful party for bad behaviour. Again, it is quite a high threshold to hit. The difference is that under the standard basis, the usual order for costs is that they must be proportionate, and that if there is any doubt as to whether they were reasonably incurred or the reasonable in amount, that is resolved in favour of the paying party. In relation to the requirement for proportionality, this is quite a new approach in English proceedings and has resulted in some slightly odd outcomes, not so much in relation to patent cases yet, but in relation to more general civil litigation. And the rules set out that costs are proportionate if they bear a reasonable relationship to the sums in issue, the value of the non-monetary relief, the complexity of the litigation, any additional work generated by the conduct of the paying party, and any wider factors such as reputation or public importance. And what the court does is first assess whether costs are reasonable, finds what the overall total which it considers to reflect the reasonably incurred and reasonable in amount costs. And then, according to a decision that was handed down this year, it should stand back from that figure and consider whether the figure of reasonable costs is also proportionate. If it is not proportionate, then the court can make a reduction in the amount of those costs. So as I mentioned, that proportionality issue has not yet been applied in IP cases, but it has resulted in some very odd results elsewhere in civil litigation. For example, in B&M and MGN Limited, which was a breach of confidence claim which settled at approximately £20,000, the legal costs of the successful party were assessed at £242,000. That was considered, whilst the costs were reasonable, that was considered disproportionate to the value of the claim and was reduced on assessment to a figure of £84,000. Similarly, in May and Wavell Group, the claim was valued at £25,000. The costs of the successful party, which it sought to recover, were £208,000. This was later reduced to £42,000. So the court is certainly getting far stricter in terms of recoverable costs than it has been previously, and this requirement for proportionality is something which litigators have to bear in mind. My personal opinion is that in most cases where there is a patent involved, the value of the injunction and the importance of the injunction will probably weigh heavily in favour of incurring costs which may outstrip the value of the underlying claim itself, simply because the value of the injunction is so important, either to the patentee or the fact that it excludes the defendant from the market would be sufficiently important to justify higher costs. But that is not something which has yet been tested in the High Court. Again, similar to what Will mentioned is the position in Canada, where the factors which the court takes into account are set out in statute. That's effectively the same in the UK. They're set out in the civil procedure rules, albeit the judge can take any factors into account given the wide discretion that they have over costs. And the factors are listed, or some of the factors are listed in the slide. What I thought might be worth doing is picking out two points, which one of which certainly is slightly peculiar to UK litigation. The first is the court will take account of the conduct of the parties and the efforts to resolve a dispute. So the civil procedure rules require parties to consider alternative dispute resolution and mediation. If a party unreasonably resists that, they can be penalised in terms of recoverable costs or the costs awarded against them if they are unsuccessful. This is generally seen as a good thing in terms of getting parties in a room together and trying to resolve the issues, although it does have the frustrating side effect that it can result in parties paying lip service to settlement and not fully engaging in the process, which is ironic. That tends to result in even more wasted costs. In a similar vein, the UK procedure has something, and it's a procedural device known as a Part 36 offer. And this is where a party makes an offer to settle the proceedings in a formal procedural style, which has costs consequences at the end of the action. And unlike the general approach which encourages parties to try and settle, where the judge has discretion as to how those costs lie at the end of the proceedings, there is very little discretion in how Part 36 offers are interpreted in terms of costs. So the way that Part 36 offers work is that they can be made by either the claimant or the defendant. If the offer is accepted, the claimant will recover their costs on a standard basis up until the date on which the offer was accepted, which is very beneficial to the claimant. If the offer is not accepted, then there are cost consequences depending on the outcome at trial. So if a defendant makes a Part 36 offer to settle the proceedings and the claimant wins but doesn't obtain a judgment which is more favourable than that offer, so the defendant may have offered to settle for 100,000, the claimant wins but only recovers damages of, say, 75,000. In those circumstances, the defendant will be entitled to their costs from the date they made the offer. So if they made that offer on the first day of proceedings, of the first day of the claim, when it was issued against them, they would recover their costs against the successful party from that date. So it can be quite a helpful defensive tool. It can also be quite a helpful aggressive and attacking tool as well, because if a claimant makes an offer and obtains judgment which is as good as or better than its offer, the defendant has to pay the claimant's costs on an indemnity basis, which means that the costs do not have to be proportionate, and any uncertainty is resolved in favour of the receiving party. They also get interest on those costs at a rate of up to 10%, and they also get an additional amount in damages which reflects up to £75,000, which reflects a percentage of the damages which were awarded. So the claimant can use Part 36 offers to put significant pressure on a defendant to accept a settlement, and quite a lot of thought goes into pitching these offers at the right level to make it worthwhile for the defendant to accept, or for the other party to accept that offer, and but benefiting from the cost consequences if they don't accept. Moving on very briefly to another procedural development which has come in over the past few years. The UK has now started a process called costs budgeting, and this was with an aim to managing costs at an early stage by limiting what attorneys can recover at a later stage post-trial. And what the parties are required to do is to submit a costs budget once pleadings have closed, which is after approximately 3 months, setting out their estimate for all of the stages for trial. So that's for expert reports, disclosure, witness evidence, experiments, the cost of trial itself is all set out at a very early stage. The parties will then try and agree that cost budget with the other side. But even if they do agree it, the court can still find that certain estimates are disproportionate or unreasonable and reduce them. At the end of trial, the party is then held to the estimate in their cost budget, which it's slightly concerning that budgets are commonly exceeded, but courts will rarely allow you to recover more than the figure in your budget. And even worse, if you fail to file a budget altogether, the client can only recover their court fees from the other side. Again, this is an issue that is there in UK proceedings and is something that parties need to be aware of, that there are budgets that they need to set. It can be used to apply cost pressure to the other side by putting in a budget which is significantly higher than the other side were maybe expecting. It's yet to really take off in patent matters, simply because there are quite a few ways of avoiding filing a budget. For example, there is a scheme called the shorter trial scheme, which doesn't require you to file a budget. Cases of more than £10 million, which will apply to a lot of patent cases, aren't required to file a budget yet. Or similarly, cases in IPEC, there's no requirement to file a budget there, which is the Intellectual Property Enterprise Court. Moving on to the Intellectual Property Enterprise Court, that is a loser pays system, but is not compensatory. And the aim is to provide the parties with certainty as to their costs. The overall recoverable costs are capped at £50,000, although the average recovery in IPEC is approximately £30,000 to £38,000, simply because the costs of each phase are also capped at a certain amount. It's accepted that £50,000 recoverable costs is far below the actual value of the cost of actually pursuing claims in IPEC, which are approximately £200,000 to £300,000 for patent matters. But that hasn't stopped the court being very popular with litigants. Parties seem happy to forego the idea of recoverable costs if they have some certainty as to what their costs exposure as a losing party may be, particularly where they're smaller companies. There is a slight unfortunate twist to that, though, is that it can result in bigger parties trying to run weaker cases simply because, unlike the High Court, where a successful defendant in a weak claim may recover 60-70% of its costs, in IPEC they will only ever recover up to £50,000. So they may be faced with a costs exposure of £200,000, and in many cases it would be better for them to run the case in the High Court. Very briefly, moving on to the process, it is very similar, I think, to what Will explained is the process in Canada, which is effectively a winner will be determined, whether that's on an issues-based matter or overall, and the parties will then serve a bill of costs setting out what they've incurred in relation to the proceedings. What is I think less akin to the Canadian system is that it's then within the successful party's control as to how quickly that process is commenced for recovering the costs. It's supposed to be commenced within 3 months, but it can take longer to commence those proceedings for recovery of costs. And then the costs process is fairly long and fairly detailed and can take many months. As a result of that, the parties do tend to agree a settlement for costs, certainly in patent matters, once the outcome of the trial is known. And at that point, there is no need for a further assessment. That was, as I said, a very quick skim through the UK. It's, I think, like Michael explained in the US, I think a developing area, although unlike the US, where a lot of the developments seem to have come from case law, the developments in the UK are very much being driven by Parliament and by the government of the day, which is very keen to reduce the overall cost of litigation. And they see the best way of doing that is to try and have some control over the recoverable costs, which a party can recover from the other side. The cost budgeting system came in about 3-4 years ago and is still under review. There is suggestions that the next phase may be to introduce fixed costs into certain proceedings in the UK, although that's unlikely to apply to patent matters. So it's very much a jurisdiction which is watch this space in terms of costs recovery. Very briefly, in relation to Germany, that's also a loser pays system, and unlike the UK, however, the fees are recoverable according to a statutory fee schedule which exists in German law. And that is quite a restrictive schedule. Like Will was explaining, the Canadian tariff is quite restrictive and doesn't reflect the actual costs incurred. The maximum recovery for a patent matter in Germany is 230,000 euros in respect of attorney's fees, and that would be for a case that's valued at 30 million euros. The majority of cases, the recoverable attorney's fees will be between 6,000 and 12,000 euros, which effectively values the claim at between a few €100,000 and up to maybe 300,000 and 400,000 euros per patent. So that covers everything I was planning to talk about from a European perspective, from England and from Germany. I don't know whether anyone has any questions on that or on what Will or Michael mentioned earlier on.
At this time, ladies and gentlemen, if you would like to ask an audio question, please press star 1. Again, that's star 1 for any audio questions. And we'll give a moment to compile the Q&A roster. And at this time, there are no audio questions. Once again, ladies and gentlemen, that's star 1 for audio questions. And at this time, there are no questions.
Thank you.
And ladies and gentlemen, that does conclude today's conference call. You may now disconnect your lines.